Happy Monday, and welcome to another episode of cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about husbands and wives committing murder. Cases that should have gone to the Supreme Court of Canada, but didn't. Sheena Cuthill, along with her husband and her brother-in-law, were all charged in the death of a Mr. Lane. Ultimately, in the course of the investigation into Mr. Lane's murder, the police obtained a production order which allowed them to get access to text messages sent by Miss Cuthill to her husband and to her brother-in-law. Ms. Cuthill argued at trial that those text messages were inadmissible because they were spousal communications. In Canada, the law protects communications between husband and wife as a specific category of privilege. Because the documents were obtained by way of a production order as opposed to a warrant, Ms. Cuthill argued that her spousal privilege was violated by police. The court disagreed, and she and her husband were both convicted of murder. They sought leave to appeal their convictions to the Supreme Court of Canada, who dismissed the appeal. It's actually very interesting that the Supreme Court of Canada denied leave to appeal this case, because this was a case that was a very interesting interpretation of recent jurisprudence that had arisen about privacy interests in text message communication, who owns that privacy interests, and digital communications generally when it comes to the issue of spousal privilege. Everybody knows that communications between husbands and wives are not just limited to conversations that occur in the home, in the bedroom, over dinner, and in those circumstances, the rule where spousal privilege traditionally arose from. Now spouses communicate by text message and by email. There's more than just verbal communication that forms part of the spousal relationship. Shouldn't all of that communication be subject to the spousal privilege exception? And if it is, shouldn't that mean that in the circumstances, spousal privilege is retained for all communications, including text messages, and therefore they're not admissible or obtainable by the police by way of a production order? The Supreme Court of Canada had the opportunity to clarify how spousal privilege applies in the digital age and the application of spousal privilege to a broad understanding of communication that now exists in our legal system. This decision not to hear this case really seems out of step with the more expanded approach to privacy and to private communication that the Supreme Court of Canada has seemed to take over the last several years. It's very interesting to me that this case didn't get leave, and it will take another circumstance where the police obtain private communications by way of a production order in a circumstance of privilege, perhaps even violating the privilege between a lawyer and their client, for the issue of privacy, privilege, and text message communications to finally be litigated at the Supreme Court of Canada. Unfortunately, that's not something we want to see happen in our legal system, and hopefully it doesn't go that far in the future. You're watching Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Please like, subscribe, share with your friends, and tune in next week for another exciting episode.